We're continuing on with our series on battery-related crimes, and in this video we're going to talk about defenses. So defenses to misdemeanor battery, felony battery, and aggravated battery. I'm Adam Rossen. I'm the founder and owner of the Rossen law firm, and I'm a former prosecutor, and we have over 400 5-star reviews on Google and Avvo. And by the end of this video, the goal is to make sure that you have a great understanding of what the defenses are and how good lawyers will use these typical defenses to get great results on their cases. So the first main defense is the same defense that we have in every kind of case, which is requiring the prosecutors to prove their case beyond and to the exclusion of every reasonable doubt. And that's the prosecutor's burden or obligation, like I said, for every single criminal case that there is. And the law says that there's 3 ways for a jury to find that reasonable doubt. So if that jury can find the reasonable doubt, if we can help them find it or show them, then they must find our clients not guilty. The first way is directly from the evidence. The second way is from a conflict in the evidence. And the third and final way is from a lack of evidence. So let me give you an example of how we do this. So let's say it's illegal to have a yellow highlighter in your right hand. And at a trial, there was evidence that there was a yellow highlighter in the left hand. Well, that doesn't satisfy all the elements of the crime. So from the evidence alone, there would be reasonable doubt. Now, let's talk about conflict of the evidence. Let's say, again, it's illegal to have this yellow highlighter in your right hand, and there's one witness that says, yes, I saw Adam and he had that yellow highlighter in his right hand. But let's say there was also a video that showed I had the yellow highlighter in my left hand. Well, then there would be a conflict of the evidence, right? There would be testimonial evidence, somebody testifying and saying they saw something, but then there would be physical evidence, a video that says, no, 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 it did not happen. And that conflict of the evidence we see in a lot of our cases. Okay, so that's a common, obviously this is a very simplified hypothetical, but we see that all the time. Now, the third way is from a lack of evidence. So again, illegal to have this yellow highlighter in your right hand, but there's one witness who says they're kind of sort of sure that they saw this, but they're not really that sure. And when the police were questioned, you find out that there was a video, but the police chose not to get the video. They chose not to secure it and save it and show you as the jury. So in that particular instance, there is a lack of evidence because the jury is going to sit there and go, well, you're giving me a witness who's not really that sure, and the police officer could have done all this extra work and chose not to. So that would be an example of a lack of evidence. Another common defense that we use is to attack the credibility of the witness or the alleged victim in these battery cases. And through our investigation, a lot of times we can find out that the victim has a motive. The victim has, whether it's financial or else, something else, they have some kind of motive to either lie or over-exaggerate. And so that's something that we do oftentimes, is really go in depth and try to attack the credibility. And we have a lot of cases where, as we've done the work to really uncover some ulterior motives, we've found out that what is alleged against our client is not what happened. And another main way that we really attack the credibility of witnesses or victims is by getting that 911 call. And these 911 calls are an extremely valuable tool for us. According to Florida law, the police departments only have to keep them for 30 days. So if you wait to hire a lawyer, that 911 tape could be gone forever. When we get hired right away, in every single case, we always request the 911 tape. And we've had cases as serious as all the way up to attempted murder aggravated assault with a deadly weapon, aggravated battery cases dismissed because we got the 911 calls. And oftentimes, again, they can refute the allegations. We can hear the tone of the witness, and when they say they were scared, they didn't sound scared. They actually sounded angry, or they were unsure about who did what or what they saw. But then when the police come, they have time to actually fabricate the story and practice, and then they sound a lot more sure in front of the police. So that 911 tape oftentimes works wonders for us. A lot of times it actually shows that the victim was the aggressor, and we can hear it on this call. But when the police come, the victims calm down, they present better, and the police believe the victim's story and then arrest our clients. So that really does help. Another defense that we use is a lack of identity, and this is often called the Shaggy Defense, from the rapper Shaggy, who had that song saying "It wasn't me." And in every case, the prosecutors have to prove identity of the defendant. So let's say there's a large fight. There's a crowd in a parking lot, and there's a large fight. It's a brawl. And the police come, and they're trying to figure out who started it or who they should arrest for battery. Well, a lot of times in those kind of cases, proving the identity of the person that actually threw a punch or actually started it is very difficult. And that's something, we as defense lawyers don't have to disprove it. The prosecutors have to prove it, again, to that beyond and to the exclusion of every reasonable doubt level. So it's very high. It's a high burden for them. Continuing on with that brawl example, if the police believe that the parties were mutual combatants, then that's another defense. So if people are agreeing to fight, if basically 2, 3, 4, 5 parties, 5 people, maybe a bunch of people are willingly engaging in a brawl, in a fight, well, then they're deemed to be mutually combatant, and then a battery charge, whatever kind of battery charge, misdemeanor, felony, wouldn't be able to stand if the parties were mutually combating or mutually fighting. So that's another common defense. We also have all of the stand your ground, right, which is self-defense, defense of others. All of those are in play on these crimes and are often used as well. And when we talk about the felony crimes, so the felony battery and the aggravated battery, one other thing we do with those is really attack the injuries. Because what someone might claim as great bodily harm might not be what the law says is great bodily harm. What somebody claims is a scar, or some kind of permanent injury, a lot of times goes away with time and isn't permanent. It might be there for a little bit, but it's not permanent. So those are ways that we can attack even, the injuries on those felony crimes. So there's a lot of things that skilled lawyers can do, to attack and defend these battery crimes. If you have any more questions, if you want any more help on that, you can always give us a call, 754-206-6200. We'd love to have you come in for a free strategy session where we're going to go in depth on the law, the defenses, and come up with your strategy from day one.